Fine. So what we're going to do is start with you, Mr. Kipnes. Come all this way and answer the questions that were directed at you, and also your closing statement if you do need to make one. Especially the one about lawyers making things simpler.
Yeah, lawyers are supposed to make things simple, but I think it's somewhere wired in their training that, if you do that, then, you don't give off this impression of knowing.
And you can't charge a lot of money.
Certainly, yeah, which is tragic. But anyway, I think that, and I'm not purporting to speak for Kipi here, I certainly think that Dr. Njuguna and Dr. Mutai can do that. But I think the reason why you want to have a process which is complicated, and complication would only go up to a point. The reason why you want a detailed process is because you want to be certain that we're not just dishing out patents at will, at random, for anything. What you want to do is interrogate the process, and that's the reason why a patent process and an application format cannot be as simple as applying for your ID, and perhaps that's complicated as it is, but it has to be slightly more detailed so that the process is interrogated. You want to look at how did you arrive at this? You want to ask the inventor that, and I think there's a good reason for that, but I think there needs to be a forum where it can be broken down for people who either don't practice at the patent bar or people who are requiring those patents, and I think lawyers, universities can do this. Can you protect software patents and copyrights as well? As in, why do we have, can't copyright suffice? I think this point has been rehashed. I mean, you have distinct aspects of protection that need to be preserved as is. And Maricel has said that we need to embrace the complication brought on by software patenting and software copyrights with a view to enriching the process as opposed to trying to make the process simpler to the extent that we would only stick to what is set in stone. When law does not evolve, when legislation, when governments do not evolve to address the needs of society, of their own society, then obviously you're stuck in a time warp, and we can see what that can do to a country. I like the example given earlier by Mugo Kibati about the ponies which were brought in by South Korea, and today South Korean cars are giving almost dollar for dollar competition to Japanese cars. I think it's important to make that distinction. My closing remark is this, that unless we get adventurous enough and hit the Kenya Industrial Property Institute with patent applications for software, then we'll never really get to know where the line can be drawn. I think that just needs to be done with all the challenges that poses. I think there's a lot to be gained in trying to help make our country that Silicon Savannah. Thank you.
Thank you very much. I'll start with the issue of whether we've had any software cases that have been prosecuted, or where we've had quite a number of them, both in the civil and criminal court. And tomorrow there's a presentation that's going to be made by Mr. Nzeveka from our office, and he's going to cover most of these details, so I don't think I'm going to belabor that particular point. And then on the issue that was raised by Kevin, it's not that software, the protection under copyright is insufficient. I think the discussion today was whether or not to protect under patents, not whether copyright versus patents. There's a big difference between that. So I think we're just looking at other means other than the protection that is already legislated, i.e. Copyright protection. Is there anything beyond that? So I think we are looking at it from the patent angle, because this is an area that has raised a lot of interest in the last couple of years. I think from even the time when I was doing my master's, which was a very long time ago, and that's the time when the EU was deciding whether or not to embrace software patents, and it's only the US which had the software patents then. So the debate and discussions we're having today are very similar to what they have. Then the other issue which always comes up in all the IP fora is the issue of the Kyondo. And I'm not even going to go into that direction. There's a very good article that has been written by one Mr. Silva Sange from the Kenya Industrial Property Institute, and I think it's available on the website. And it covers all those issues, and yeah, that's why I'm saying we won't even engage in that discussion. It's much easier for you to go and read that article, for you to be able to see, based on what David said today, would a Kyondo be patentable? Would it fulfill the 3 criteria of patentability? So let's read that article. Just go to the Wikipia website and deal with it. And then I think for the rest of the issues as they relate to software and copyright, I think we have a session tomorrow morning. And then after that, if you have any further questions on that, we'll be able to answer them then. Thank you.